Adams, what are you here for?
Uh, Blake Adams for Plaintiff Chronicle Holding Company in the application for prejudgment garnishment.
What what case is that?
It's GN-25-000970.
25. Oh, Chronicle Holding Company. That case is
Yes, Your
set
Honor.
for in person, and I've already done the in person docket. It's not set for a remote hearing.
Hmm. It was set for in person. Yes, Your Honor. I did get the email saying it was switched to remote.
No, from who? Not from us.
Hmm. Well, then I will
Sorry. Yeah, I don't think you could
reassess.
do a. Um,
Hmm. Yeah, it was highlighted in yellow for the remote. Um,
on
I'd set
what?
it for in person, but
Oh, Ms. Matashek Steele says she may have accidentally highlighted it.
oh,
Um, all right. I will just I don't know what we'll do with you. I'm gonna hang on. We don't do Zoom every day anymore, thank God. And but Zoom continues to update things. And it's very annoying because then I don't know how to do it anymore. I'm gonna move you to a breakout room that's not labeled with your case, Mr. Adams, but I know that you're there. I'll talk to you when I get through this, okay? I'm sorry about
I'm
the
I'm
confusion.
Mr. Copey, Your Honor.
Just give me a minute, please.
Oh, sorry.
Okay. All right. So I've done that. So then, yeah. So Mr. Copey, what case are you here for?
On the Ahmed or Shabazz and versus Ahmed.
Oh yeah. So I called that case and you were not here. So
I'm
now you're
sorry.
here. Who do you
I was
represent?
logged in at like 8:45 and I got kicked out a couple times and I kept trying to log back in. I apologize.
Who do you represent?
I represent the defendant. And plaintiff counsel did email me early this morning and tell me that he was unopposed to the order that we filed.
There was one other person I thought. I do not like the way they've done this. Mr. Getty,
Yes, Your Honor.
you
So
got
I
to
was
turn your
here.
camera on.
Can you see
Did
me
you turn
now?
it on? All right. Yeah. What case are you here for?
Your Honor, I'm here for the McFarland case. I logged on before 9 and
I know, but you weren't listening or paying attention. We could see your back for about 15 minutes and I couldn't get your attention, so I kicked you out. So
oh,
I'm
my
aware.
apologies. My apologies, Your Honor.
All right. So who do you represent?
So I represent Intergalactic Network. We were not a party to the motion. It was between the plaintiff and one of the other defendants.
Well, there was a Jasmine Nowlin here who says she represents Intergalactic. I'm going to put you in the breakout room with them and
Okay, thank you,
I'll
Your Honor.
talk to you when you come
There's
back.
several defendants.
Okay. Well, what a morning. This is why I don't like Zoom. All right. And thank you for your patience, Ms. Wyatt and Ms. Vaughn. Now let me find, I have a 8-page docket here, so now I have to find where your case is. That's still a no show. All right, here you are.
Monday,
Okay.
Your Honor.
I'm sorry.
Happy Monday.
Yes, exactly. So this is the Wilhelm versus Johnson. It's a motion to continue. Whose motion is it?
Plaintiff's motion, Your Honor.
All right, let's hear it.
Yes, Your Honor. This is a first trial setting. We're set for trial on March 24th. We're seeking a continuance based upon additional discovery that's needed in this matter. There's a motion to leave to designate a responsible third party followed by defendants that needs to be ruled on by the court, as well as further discovery on that issue. We also have outstanding discovery with deposition by written question for defendant's cell phone that was filed prior to the discovery period ending. And we also have a accident reconstructionist for defendants that needs a deposition. And we finally got that deposition set for the 12th of March, but that's not all. The deadlines have passed in order to contest the qualifications for this defendant. And we've asked for that deposition prior to the discovery deadline expiring as well. Additionally, as a personal matter, I'm due with a child the week after this trial is set. So I'm not medically cleared to travel. And while I do have other people at my firm that can have this case set, and try the case for me, Based upon the additional discovery that's needed, we would request a continuance. And during my absence, I will be having other counsel that will oversee the case and make sure it does move forward. But because of these reasons, we are requesting a trial setting that's just be continued and have a different trial setting.
All right, Ms. Wyatt?
Yes, Your Honor. Plaintiff's opposed motion for continuance was not verified. It's just wanted to bring that to the court's attention.
I did just see that.
And additionally, Your Honor, I mean, the main basis for our opposition to the continuance is we filed an answer. Well, sorry, let me back up. The lawsuit was filed October 2023. We filed an answer shortly afterwards. And within, I believe, 3 months, the plaintiff's counsel pushed for trial dates. They continually emailed us for trial dates. We agreed to set this trial. This has not been a surprise. None of the discovery that's been brought up by Ms. Bond is a surprise. The cell phone records that she's mentioning, they've had the cell phone number for a while now. They did not choose to subpoena the cell phone records. And tangentially, there's not even an issue of relevance, in our opinion, as to the cell phone records. The accident reconstructionist deposition that she's seeking to obtain, that expert was designated December 2024. I don't know why there was a delay in setting the deposition. So there's not real relevant discovery that is pending. Additionally, he's our expert. We're going to bring him live at trial. So that's, we don't feel that there's any good cause for a continuance.
Ms. Vaughn, the biggest problem you have is that your motion for continuance is not verified. And so it's not a motion at all. I mean, if there was no opposition, that'd be great. I'd grant it, but there is. And so I can't. I'm sorry.
Yes, Your Honor.
Okay.
Is it permissible by the court to get this refiled and I guess reheard?
Yeah, I mean, you can do that. Sure. Get it verified and get it set. I don't mind, but I can't grant this one. So the motion's denied. Thank you so much. That concludes the hearing. You're both excused.
Thank you, Your Honor.
Yep. Sorry about that. All right, let's see. I guess I'm going to bring in A to Z, the Honey Kobe, whatever his name is. Mr. Compte, you're here on a motion to withdraw. Is that right? You have to take yourself off mute, Mr. Compte.
Okay, sorry about that, Your Honor. Yes, we're here on a motion to withdraw that we filed.
And go ahead and talk me through it.
Okay, we were hired on this case from the initial filing of the petition by the plaintiff.
You know what? Let's stop there. Where you I'm looking at your defense counsel's first amended motion to withdraw as counsel, right? That's you?
Yes, Your Honor.
Okay. And that was filed February 27th.
We filed an amended one after we set the hearing, yes, Your Honor.
Okay. So if you filed it after you set the hearing, did you send a new notice of hearing?
I did in my attachments, there's one letter where I tell him we're withdrawing and I give him a copy of the notice. And the second letter on the 27th, I believe I let him know when the court has set it for
Did
hearing.
you give him formal notice of this hearing and notice of your motion?
Yes, Your Honor, I did. I sent him an email.
That's what I'm looking for because I don't see it. I'm looking at a motion, this motion filed February 27th. You served yourself. You served Mr. Conant. And that's it. Your client is not served.
Are you saying through the electronic filing with the court?
Through any way of true service.
In the email that I sent him, I let him know on a February 26th.
An email is not service. It's not due process notice of a hearing when someone doesn't show up.
Okay, I understand, Your Honor. He let me know he would not be attending.
Your client did?
Yes, and he wasn't opposed to it, and he let me know.
Did you get his signature on the order then?
No, Your Honor, not on the order. I did attach the email where he said he was unopposed to the withdrawal.
I cannot grant a motion to withdraw when the client hasn't signed anything, or I don't have evidence in my court file that they have received proper formal a copy of the motion through proper service and proper notice of the hearing, right? And I just don't think I have that.
Oh.
Um,
Yes, Your Honor. I believe we thought we were complying with the rule when we had him respond in writing that he was unopposed to the withdrawal, and that's why I attached that. And then when I sent him the letter, I gave him notice of the hearing date, and he responded that he wouldn't be attending and he didn't oppose. Could
yeah,
I file a amended order with his signature on it? Would that
sure.
please
Yeah. If you
work?
can get his signature, and Mr. Conan's signature, you could just send that in on submission. That'd be the easiest thing to do.
Okay, Mr. Conant let me know this morning he was unopposed around 8:30. So
Right. You've given him notice that, so I'm okay. I'm just saying if you want to send it on submission, you're going to need his signature and your client's signature.
okay, then I will do that.
Okay. Thank you so much. Sorry about this.
No,
You have a
thank you,
good
Your Honor.
day.
Appreciate it.
That concludes the hearing. All right, welcome back. I think you're here on a motion to continue. Is that right?
That's correct.
right, Your Honor.
All right. And I'm going to see if I can find the file and get it open, but I'm ready to hear whoever, I don't know whose motion it is. I'm ready to hear it.
It's Mr. Lee.
It is my motion, Your Honor.
All right, Mr. Lacy.
I represent defendant, WC Paradise Cove Marina, LP, as the defendant in this case. It's a case that involves injuries from a fall on a dock there at the marina. Paradise Cove Marina has a system of docks that can move out into the water to accommodate Lake Travis, varying levels of their lake. And so those docks have concrete tiles on them that are fixed into a grid system. One of those tiles appears to have failed or gotten dislodged, and Mr. Ball, the plaintiff in this case, fell through that concrete tile about 2 feet down into the infrastructure of the floating dock. So he is claiming injuries, the most serious of which appears to be injury to his neck, that he is claiming that he is going to require surgery for. And in fact, has apparently scheduled surgery for later this month, in March sometime. We don't know the exact date, but maybe plaintiff's counsel can let us know on that. But basically, the case is set for trial on April the 7th of this year, but we have not taken any of the expert depositions yet. Plaintiff has identified 2 expert witnesses, a neurosurgeon and a pain medicine doctor who has provided us a life care plan, which was just provided when they had to designate experts in December of this year, of last year, I'm sorry, of 2024. We need to depose those 2 experts, and then we have identified 2 experts in our expert designations, which were due January 15th of this year. So there's not been a lot of time to do those depositions. I don't think there's been unreasonable delay by either party in this case. I set out a timeline in our reply to plaintiff's response that kind of sets out when everything happened. And the biggest problem we had is that after we got the basic discovery done, like the written discovery, gathering medical records, taking plaintiff's deposition, and taking our corporate representative's deposition, my client filed for Chapter 11 bankruptcy, unrelated to this case, but it was a bankruptcy filing. And so that, due to the automatic stay, we didn't get anything done for about a year. All through that, we worked with plaintiff's counsel. They eventually signed and agreed to a bankruptcy stipulation that was filed with the bankruptcy court, limiting any damages to the insurance policy limits. That was approved back in August of 2024. And so right after that, we set up a docket control order and we started moving forward with the case again. Bottom line is that we're just not quite ready to try this case yet because some of the expert witnesses, some of the key expert witnesses have not been deposed yet. And that's the basis of our motion.
All right, thank you. Ms. Tavares?
Judge, plaintiff is opposing this motion. This case is quite old and the incident is quite old. Part of the delay, though, in getting this case started as well was that Paradise Cove Marina was properly served through the registered agent, and for months they did not do anything. We had to file a motion or threaten to file a motion for a default judgment. This was when another attorney from my office had this case, judge. This is how old the case is. And then it wasn't until then that they decided to make their, I guess, insurance company aware that this was going on. And I think that this just is an indication of how the defendant, Paradise Cove Marina, is waiting for the last minute to do some things. Mr. Lacey is correct. There was a stay, or there was a temporary kind of halt in the case because of the bankruptcy. Again, this is nothing that plaintiff did. This is something that the defendant chose to do that is further delaying the case. We signed that stipulation agreeing that we would not seek more than just the insurance coverage here, hoping that this would not be a cause for a delay. It was after that we got the DCO, the agreed DCO. Plaintiff believes that at that point had defendant, and these expert deadlines were the same in the DCO. So at that point, had defendant felt like that was inappropriate, that would have been the right time to bring those things up. Mr. Ball is just getting, I mean, again, just very increasingly frustrated that it's delay after delay. His surgery is scheduled for March 19th, Judge. We have spoken to his doctor, Dr. Sani, who stated that he will be able to be present for the trial. In Mr. Lacey's or defendant's response to my reply, they say that they needed to depose Dr. Sani, because of the surgery. We have had the surgery recommendation since 2023. So there has been plenty of time for them to depose Dr. Sani. So plaintiff's arguments are the only true expert reports, because Dr. Sani is not a retained expert, he's just a medical provider, are Life Care Plan and The Economist. And we have told defense counsel that we will make ourselves available and we will make our experts available before this April 7th trial date. And they have not given us an answer as to why that cannot happen, just besides they don't want to rush.
All right. Any reply, Mr. Lacey?
Your Honor, I would point out that number one, we're trying to get this case resolved. We have mediated the case twice. We mediated in October of 2024, and then we mediated again in February of 2025. So February the 20th, just a few weeks ago. We mediated a second time. Now, we purposely were not scheduling expert witness depositions of medical experts prior to those mediations because we were trying to not make either party spend a bunch of money on depositions if, in fact, we could get the case resolved. And we are in good faith. We've been trying to get that done. It has not happened, but we weren't just sitting on our hands, not taking those depositions purposely. We were purposely not trying to make the parties expend any more money until we saw whether or not we could get the case resolved. The other point I would make real quickly is simply that Mr. Ball is having a surgery on March the 19th and trial is set for April the 7th. Our concern, sure, we have a concern that Mr. Ball, whether or not he should be in trial or not, plaintiff says that's not going to be a problem, but it's potentially prejudicial to my client as well for him to be sitting there right after a surgery. I don't know what kind of bandages he's going to have or neck brace or anything else. I just think this is a situation, unfortunately, where we need to push the trial back. And this is our first continuance. We haven't done this previously. We haven't come before the court and asked for continuance previously, and therefore we would ask that this case be pushed back.
Well, it doesn't sound like there's a lot of discovery that actually is left. It's just these couple of depots. Um, I'm sure you can handle working something out with the plaintiff. I mean, I would think the plaintiff wouldn't want to go to trial right after surgery. But if he does, then, I like to let the plaintiff drive their case. So I'm going to deny the motion. I think you have time to get those things done before April 7th. All right. Good luck. That concludes the hearing. Thank you both.
Good.
Thank you, Your Honor.
I'm gonna bring that guy who showed up on Zoom in, Miss Dubois. Okay. So this is some kind of debt case, I think. Prejudgment writ of garnishment. All right, Mr. Adams, how are you?
Good. I apologize for the misunderstanding, Your Honor.
That's
I
all
received that
right.
email saying it. So, but,
Yeah, so it can be confusing. There are some judges who will convert cases to Zoom without soliciting input from the lawyers. I'm not one of them, but there's no reason for you to have all of us memorized. So I did not intend to do that. It was just an error on my part. So don't feel bad. The thing I'm trying to figure out is application for a prejudgment writ of garnishment. I mean, did you serve anyone? It looks
I
like you were
haven't served.
here before on submission, but it's not agreed. So you can't send it in on submission. So you're gonna have to explain this one to me and why you get to proceed without anyone else here.
Sure. So this is in reference to the original case in the 261st. It's a contract case 25-000738. It's
I'm sorry. So it's D1GN25. What was it?
000738.
0738. That's the judgment that you say backs up this case that you
That's the
have
pending
filed?
suit that this
That's the
prejudgment
pending
garnishment
suit.
sought.
Okay. All right.
I tried to set this with the 261st, but they pushed me over with the central docket. So it's a contract case, approximately $400,000 in controversy here. I did have a call with the defendant in that case, Brandon Heron. There's been some fraudulent activity where he impersonated another person and in an attempt to elicit a $65,000 wire from my client. We did actually report this activity to the Federal Bureau of Investigation in Oklahoma City. They have opened a case into this, seeking, investigating this further. I've been in contact with Paige Lang, special agent out of the Oklahoma City office. And the defendant in that case is actively selling things on Facebook. I've been in contact with some of the Chronicle Holding Company and or AgX Trade LLC employees about this. He's been actively selling what we think was purchased using misused funds that were extended to that defendant. And I'm not sure when they're going to actually take that case, but it's moving along quite a bit with the FBI. And we're seeking a prejudgment writ. This is not something we would normally do, but because of the alleged activity and with the case being opened with the FBI, we feel that a prejudgment garnishment is definitely appropriate in this case.
So I don't, this is not a cause of action that I am overly familiar with, a prejudgment
Nor
writ.
myself.
So
Your
I
Honor.
don't know what allows you to do this? Like what law can I look at to see whether
So under
what the burden you have to meet? You're gonna have to do more work to
sure,
get me
sure.
there because
Under
I don't.
Rule 650, sure. Under Rule 658, an application for writ of garnishment and order. The rule says either at the commencement of a suit or any time during its progress, the plaintiff may file an application for a writ of garnishment, and such application shall be supported by affidavits of the plaintiff, his agent, his attorney. Those affidavits are in the original application. We did include an affidavit for myself, and where the defendant Brandon Herron, AGEX brought me in to sort of investigate this, and that's whenever he made that misrepresentation to me. He then confirmed that he misrepresented to me in a text message. I then instructed Basil Parks, one of the AGEX trade employees, to record a phone call with Mr. Herron. He did admit to impersonating his wife to try to elicit a $65,000 wire from my client. And AGEX Trade, it's actually Chronicle Holding Company it's the holding company for AGEX Trade. And in doing so, that's what supports is included in those affidavits on both the application and also in the original first amended petition in the original suit. And yeah, it's that whole first paragraph. The application shall comply with all statutory requirements, state the grounds for issuing the writ, and the specific facts relied upon by the plaintiff to warrant the required findings by the court.
But I don't see anything in this rule that says the defendant or the alleged debtor doesn't get an opportunity to respond to the request. It says it may be ex parte, but it doesn't say it has to be.
Okay.
I
filed this. We filed this ex parte. But if I could motion for leave to go serve the defendant for this, if the court deems that appropriate, I'm happy to serve the defendant for this hearing.
So go ahead.
Their original answer is due on the 10th of this month in the underlying case. And so we're a week out from them having to answer in the original contract suit anyways.
Okay.
So,
I mean, so generally I would expect you to be coming in with a lot of argument about, everything's going to be, whatever for some kind of emergency relief, the reason it needs to be ex parte, something like that. I mean, I will look at what you wrote. I cannot read all 36 pages right now. I have another hearing still, but I can take it under advisement and look at it. But I just want you to be aware, I may decide it's not appropriate for an ex parte decision, or I may just decide it's fine and I see it and I grant it, or I could just say, I'll do it ex parte, but I'm denying it. So I don't know those, to me, it seems like those are the three possible outcomes, right, of me taking it under advisement. So I'm happy to do that if that's what you want. I think you could also, the thing is, I don't think you can leave here if I take it under advisement and set it again, giving him notice. Sure. I think you have to kind of decide which way you want to go.
We, at this point, we would rather try to pursue the ex parte order here.
Okay.
Simply because it's so close to him having to answer in the original suit anyways.
Okay.
And so if he does end up answering, we will, reset for a
something else. Okay, that sounds fine. Then I'm going to take it under advisement so I can read everything you've provided the court and see whether it justifies an ex parte writ of garnishment or not. Okay. Is there anything else you want to tell me before I do that?
We have submitted if the order is granted, we have submitted a motion asking for leave to, excuse me, just one second. to deposit funds with the garnishee bank in lieu of a bond. And a lot of that would depend on what the amount of the bond the court would set under Rule 14C. Under Rule 14C, we can, of course, deposit cash or a negotiable instrument. We're not a financial institution, so we would just be fine depositing cash with that institution. I spoke with the CEO of AgX today and posited that possibility before him. It said, would you be okay with depositing cash with them? Because they are an FDIC, and he was totally fine with it. So, so we would like to ask the court to consider that motion to leave if the motion for the prejudgment writ is granted.
Okay. Did you put any extra materials in box, or is it just all in the filing with the motion?
It's all in the filing with the motion. I did
Okay.
include the original petition under the 738 case, which does include a lot of, because we do allege common law fraud in the original petition in there, which is a lot of our basis for this prejudgment writ of garnishment is that common law fraud, that active selling of assets on Facebook Marketplace and whatnot. And so that is also, yes, I've included those petitions in that box.
Okay.
As we hope the court would consider that original petition as part of this prejudgment, this motion for prejudgment garnishment.
Well, then let me take it under advisement and take a look at it, and I'll see what I can do. All right. All right. Thank you, Mr. Adams. I appreciate it.
Thank you, Your Honor.
You're welcome. Thank you. You are excused. Ms. Matashik Steele, will you check in with the other case, the motion to compel case, and see if they're finished making all the progress they could make, or if they would like some more time?
That McFarland case?
McFarland, yes. Thank you.
I'll go check.
Thank you.
Hate that it mutes me. They're ready. They said
They're ready. Okay.
completed their face-to-face. And they were not talking when I went in, so they were done. I don't know if that's a good sign or a bad sign.
Probably bad. All right. Thank you. I'm going to bring them out. All right. Welcome back, everybody. I want to clear up who represents who before we go any further. So, Mr. Berlanga, you represent the plaintiff.
Correct, Your Honor.
Right?
That is correct.
And Ms. Nowlin, you represent Intergalactic Networking and Mr. Luvano.
Yes, Your Honor.
And Mr. Getty, who do you represent?
Grand Trade Incorporated, Your Honor. My apologies.
Okay. Have these other defendants been served? Does anyone know?
They have.
Ortiz, Verdan, Volter, were they given notice of this motion?
They were. I believe Ms. Nolan's firm also represents the other defendants aside from.
Ms. Nolan, do you also represent Mr. Ortiz, Mr. or Mrs. Verdan, and Voltaire Services?
Yes, Your Honor.
Okay. That would have been good to know. All right, then everyone's represented and everyone's lawyer is here. Mr. Berlanga, this is your motion to compel, is that right?
That's correct, Your Honor.
Okay, I'm ready to hear it.
Okay, so this is really pretty straightforward. We've tried to reach out to Ms. Nolan to schedule the deposition of Mr. Lovano, actually Intergalactic Networking. Mr. Lovano is the principal, and he will likely be the representative. Ms. Nolan's in her firm has had trouble communicating with the client. It's not for any lack of trying. And we actually were here several months ago. I couldn't get dates. And so before the hearing, Ms. Nolan's firm did make contact with the client. He said he would show up. We scheduled the deposition and he didn't show. So we're back here again. And so at this point, all I'm asking is for the court to order his deposition for a date certain. And then hopefully with an order in hand, Ms. Nolan can get him to come and sit for it. And the parties have agreed to a date, March 10th, and the order has been uploaded. And so our request is just that the court enter that order setting his date for his deposition for March 10th. And that is defendant Intergalactic Networking.
Okay. Any response, Ms. Nowlin?
No, Your Honor, just that we agreed to that March 10th in the afternoon.
Okay. Anything to add, Mr. Getty?
No, Your Honor, we're available that date and we're 100% agreeable.
All right. And you've put an updated order in box for me?
There is an order. It's been uploaded previously.
So I need to add the date to it?
I can add the date.
I don't care.
Okay. Yes.
I'm just trying to, I need to know what I need to do. I have a pen. I can write March 10th, 2025 anywhere. I just need to know, like, do I need to check it or is it already done?
Yes, Your Honor, there is a blank for the date to be input.
Okay, wonderful. Then I'm happy to grant that motion. I will do that. Get it filed today. You should get it within a day or two. This one seems like you're going to need it pretty fast. So I'll ask Ms. Matashek Steele to send it to you today when she gets it filed. Okay.
Thank you, Your Honor.
So you'll all have a copy of it. All right. Well, thank you for working together. I appreciate it. That concludes the hearing and you're all excused.
Thank you very much.
Thank you, Your Honor.
Thank you.
And I think that concludes the docket. So I'm going to shut down. Good afternoon, everyone. Welcome to the 459th District Court. My name's Maya Guerra Gamble, and I'm the judge in here. We have 3 cases. Sorry, I have a couple of monitors going this morning. So I'm going to call them, see who's here for them, if you still need time, etc. Georgian versus RIBV Holdings. Anyone here for the plaintiff? No? Anyone here for the defendant?
Yes, Your Honor. Sonia Alfaro on behalf of the defendant, RIBV Holdings, and I see plaintiff's counsel.
Sorry, Judge. Sorry, I had it on. I had it on mute, and yes, my name is Michael Balsazak. I'm here for the plaintiff.
Okay. And it says motion for summary judgment, and you think you need 30 minutes?
30 or less. Yes, Your Honor.
All right. Thank you. 5-2, Riley versus Mac, etc.
I'm here, Judge. I don't know if you can hear me.
I can.
Oh, great. It wasn't working earlier, so I'm here.
Oh, well, I'm glad it's working now, Mr. Kelly. Thank you. Anyone here for the defendants?
Yes, Your Honor. Roy McKay.
Wonderful. And this is a motion to refer to arbitration. Is that right?
Yes, Your Honor. You heard an almost identical motion. I think we can probably do it in 10 to 15 minutes because of that.
Okay. Great. Well, we'll get there. And then the last case I have is Hyder versus Safeco Insurance Company.
Charlie Dunn for the plaintiff, Your Honor. Maybe 15 minutes at the most.
All right.
Go on Hardesty for the defendant. I don't even think it should take 15 minutes.
Okay. All right. Well, we'll just take the 3 cases in order, which means I'll put the other 2 cases in breakout rooms. Honestly, it's just for my convenience to not have so many screens open in front of me. That makes me easier to see who's talking and that kind of thing. So let me open those up and then I'll open the room. I'm assigning people right now. If you're wondering what I'm doing. So I'm going to open them, just go in there. It doesn't seem like these are cases where there's much to work out, but on the off chance there is, please give it a try while you're in there. Don't just turn your cameras off and ignore each other. All right. So I'm going to open those rooms now. So let's see. Motion for summary judgment, no evidence, summary judgment. So no record. We can go off the record now and I'll hear your motion.
Good afternoon, Your Honor. Attorney Alfaro on behalf of defendant RIBV. In this case, just a brief history of the facts of the case. Plaintiff was hired by the defendant RIBV Holdings on or about August 2019. She was a salesperson. She was actually recommended for the position by a male whose name is John Weaver, as they had worked previously at another employer. She comes in, they start building a team of folks, sales folks, which ultimately ends up building into 9 different people, and they're assigned to different territories. On around May 15, 2020, plaintiff, together with other individuals, is placed on a performance improvement plan. She sent an email disputing the metrics that were alleged in the performance improvement plan, but nonetheless, she went for the plan. It was a 30-day plan. She actually passed the plan and was taken off of it June 15, 2020. About 15 days later, the company learns that she had filed an EEOC charge claiming discrimination for placing her on a performance improvement plan. She never reported this to the company, even though she had signed a handbook that established that she should come to HR with those kind of claims. Her employment continued up until October 2020, when the company decides that the current structure of these salespeople is not working. So they they terminated in a reduction in force plaintiff as well as 2 other males. Plaintiff admits to this. She knows this. She testified this under oath. Later on, essentially the entire sales team was let go as well. The plaintiff alleges in this case, sex discrimination and retaliation. It is defendant's position that as it is explained in the motion for summary judgment, together with the evidence in support therein provided, that both the discrimination and the retaliation claim that plaintiff brings forth fails. Number 1, with regards to her prima facie case, she needs to prove she's a female, that she was qualified for the position, that she suffered an adverse employment action, and that she was treated differently than those in the protected class or replaced. For purposes of this discussion, we can agree to all the elements except her being able to prove that she was treated differently than other males, clearly because she was not the only one that participated in the RIF. There were other 2 males, and she recognizes and knows that. Plaintiff cannot show either that she was replaced in her position. In going into plaintiff's opposition, it is plaintiff's proposition that John Weaver, who at a certain point in time supervised her at the company and who was actually the person that recommended her for this position, replaced her. Nonetheless, Your Honor, that argument we understand falls flat on its face. John Weaver was working for the company long before the plaintiff was working for the company. He did change from a director supervisory role into a sole or individual contributor role, but this was even before the plaintiff was terminated from her position. Plaintiff has not provided any evidence whatsoever that after she left, her or any other males were replaced in their positions. Therefore, Your Honor, we believe that she doesn't comply with her prima facie test because she has not been able to prove, 1, that she was treated differently than males, or 2, that she was replaced in her position. Even if the court were to find that she meets her prima facie case, it is our position as well that she still would not meet and has not met the pretext standard. In this case, the company has established that they had a legitimate business reason. They were restructuring their sales force. It wasn't working for them. Therefore, they kind of got rid of all of them. Plaintiff has provided nothing, absolutely nothing, to say that that reason was untrue or was pretextual. Again, the only thing that plaintiff claims is that she was replaced in the position by John Weaver. And more specifically, she claims in her opposition that she was replaced in the territory of Austin. When we look at the evidence that they have provided, which is John Weaver's testimony with regards to that, that is not true. John Weaver and plaintiff at a certain point in time worked the Texas territories, which is a huge territory, not exclusively Austin. So it wasn't like she was working the Austin territory. She was riffed and he came and started working in the Austin territory. There's nothing in the exhibit provided by the plaintiffs that established that she was working in the Austin territory. As to the retaliation, Your Honor, our allegations are essentially the same. This was a legitimate business reason. She was riffed together with other 2 males. She's provided no evidence whatsoever other than temporal proximity. But we know that temporal proximity with an adverse employment action is only an assumption. Once the employer comes in with a valid, legitimate business reason for the termination, then it comes back to the plaintiff, the burden to establish that that was in fact pretext. And she can't just simply establish it with a self-serving affidavit. She has to come in and provide evidence of the same. Again, in this case, that hasn't happened. There is no evidence that this was pretextual. Based on all of that, Your Honor, and again, the supporting evidence that we have, we believe that plaintiff has failed and does not comply with either her discrimination or her retaliation claims based on sex. We know that it is not very common to grant motion for summary judgment with regards to employment cases. However, in cases such as this one, Your Honor, where there is simply no evidence to go beyond where plaintiff needs to go, we believe that motion for summary judgment should be granted.
All right. Thank you. Mr. Balthazar.
Thank you, Judge. So the facts, as stated, are generally true. On the gender discrimination, on the 4th element, there is a fact issue as to whether John Weaver replaced her, because John Weaver was not in any sales role at all. He was in a director position prior to him becoming a salesperson, which only happened after she had made her, number 1, she made her charge in June, but she testified, or her declaration states, that she complained starting in February about disparate treatment from John Weaver. And only after all of that, and she complained to John and she complained to HR. Only after that happened did he become a salesperson. And she was the only person in Austin. And he was in Austin too. And in her declaration, you'll see, he was contacting people that she was associated with. She was going to his contacts in the Austin area to try and drum up business as a salesperson. So, and he testified, and I pointed out in his deposition, he testified that he started doing sales in Austin right before Nicole got fired and has been in that position since then for 5 years. He still lives in Austin. He still does sales. He hasn't gone to another position. There's no one else in Austin doing that job. So to me, there's at least a fact issue as to whether he was replaced. He replaced the plaintiff. In regard to pretext, one, I pointed out the Brady case in regard to, I'll let you read that. But in regard to pretext, the standard is whether it's not worthy of credence, the reason that they gave. And again, there's a fact issue of whether or not it's worthy of credence, because they riffed the only person who worked in Austin and had a need for a sales presence in Austin. That was John Weaver. He continued to do that. So it begs the question, why would you get rid of the only person in Austin when you still need someone to do the Austin work, which John Weaver started to do? In regard to retaliation, again, one of the things the plaintiffs point out is, or state, is that they didn't know about the June charge when she was put on the PIP. But they did know, John Weaver knew, and HR knew that she had complained about sex discrimination by John starting in February. So that, and the argument that the plaintiff makes is this was coming from John. He did not like the fact that she was making waves about sex discrimination. So as we point out, they started taking accounts away from her. They stopped inviting her to meetings. They cut off her access to software in the company. All these things were happening beginning almost immediately after she made her complaints in February, and they continued on. She filed her charge in June. She was fired in October. And as I point out, there's case law that says that temporal proximity of 4 months or less can be seen as pretext. So I don't think it matters. I think the plaintiff's argument, the defendant's argument, is trying to go back to the prima facie part of that and the fourth prong, rather than the pretextual part that I'm talking about. The pretext argument, again, on both gender discrimination and retaliation, is the idea that it doesn't make any sense that John Weaver would do the work when they already had someone. If the story is, we don't need you anymore to do this work, that's just not true. And to me, it raises that fact issue as to whether there is pretext here or not. So we think the motion for summary judgment should be denied, Judge.
All right. Thank you so much. Do you have a brief reply, Ms. Alfaro?
Yes, very brief, Your Honor. I do want to clarify. John Weaver was the chief growth officer, which was in charge of all the salespeople. Hence, he recommended the plaintiff when she came on board. During the time he was in that position, he decided he didn't like the supervisory position, and as he stated during his deposition, and he moved to an individual contributor position. That is what happened here. Therefore, and this is where the clarification comes in, at the time of the RIF where the plaintiff was terminated, John Weaver had nothing to do with the termination because he was not her supervisor at the time. It was a very different person that handled her termination. That's number one. I think plaintiff tries to establish that all of this is pretextual, but for motions for summary judgment, we have to come forth with evidence. Just saying that John Weaver had her position or did the position is not sufficient. Yes, he was changed to a sole contributor position, but he was hired into the company before she was. Everybody else that was originally in her position ended up being riffed as well, as is established in the evidence. So one thing, I don't know how it leads to the other. Third, I reaffirm temporal proximity, yes, can be used to establish some sort of discrimination, but when it comes to a legitimate business reason proffered by the employer for the timing, it is on the plaintiff to prove that there was some type of evidence regarding discrimination or retaliation, which in this case, there is no such evidence. I understand that she could have believed that, but believes in speculation and conjecture are not evidence that could defeat a motion for summary judgment. Hence again, Your Honor, we reaffirm our position and our request that the claims of plaintiff be summarily dismissed.
All right. Well, I'm going to take it under advisement. Do you have a trial setting or anything like that coming up? Oh, I can't hear you.
Yes, we do, Your Honor. This case is set for trial, if I'm not mistaken, in April.
What day? Do you know?
Give me a couple of minutes. I will be able to tell you that. Your Honor, I believe the trial setting starts on the 21st of April.
Okay. And have you gone to mediation yet?
No, Your Honor.
Okay. You know you have to do that before you go to trial.
Yes, we've been in communications with opposing counsel, but had not gotten any response as to the mediation.
Well, I would suggest setting a date because you don't want to have to scramble at the last second if I don't grant this. So, all right, I'm going to take it under advisement. That concludes your hearing. Thank you both very much, and you're free to go. Have a good day.
Thank you, Your Honor. Much appreciated.
Thank you. I'm going to bring out the Riley case. Okay, wonderful. Welcome back.
Thank you,
And I understand we have a motion to refer to arbitration, and I'm ready to hear about it.
Yes, Your Honor. You may not remember it wasn't a long hearing or anything, but we did have a hearing in this matter about a year ago. And what it was, so this is, the brief is, this was a slip and fall at an apartment complex, and the person who fell was a tenant. The apartment's lease includes an arbitration provision that has a 1-year period of limitations. We argued the court should enforce that agreement and dismiss the case, which the court did after subsequent briefing. The court, wanted to know some things about costs and other things to assess the arbitration provision. Ultimately, you signed an order dismissing the claims against that party, and that was Mid-America Apartments LP.
This is the older lady.
Yes,
I
Your
remember
Honor.
that.
Importantly, at the time, there were about 6 other entities that hadn't appeared, but that had been named. So only MAA LP moved at that time because it was the only one we'd appeared on. Counsel and I worked about these other entities. A lot of them were merged into the 2 entities, MAA LP and MAAC, which is the one that's left. They'd been merged. Counsel and I worked well together. It took a while, but we figured out the entity issues. He was satisfied with our explanations, and we got down to we just have one entity left, that other than that previously dismissed entity, MAAC. MAAC is the general partner of MAALP. That is its role, its connection, etc. And I won't rehash all the arbitration issues because the court's already heard it, determined it, made an order on MAALP, and said this is enforceable, and I'm going to dismiss claims based on it. So, and counsel's only reply was about the entity issue, saying, well, they're not a signatory, so they shouldn't be able to enforce it. And that's what I'll focus on. And I don't need long. We did file a reply. I've uploaded that reply into the box, also the motion. But the reply has a case called Enrique Rubiola, Texas Supreme Court 2011. It's directly on point. It's a corporate entity. You have a definition of the party that includes related entities and related others, even if they didn't sign. And the Supreme Court said, yes, those parties can absolutely enforce this agreement. If you look at the exhibits to our motion, and it's in the full, I just did it with I uploaded the main motion with all of the exhibits already attached. Page 30 of the PDF, 30 to 31, it's at the very bottom of the page, is 24.1 of the arbitration agreement. And that arbitration agreement, it's also called out, of course, in the motion, we flop it out, but 24.1 says that landlord is defined to include all affiliated companies. As the general partner of MAALP, it would be an affiliated company. I looked up the definition of affiliated before we started just to have that, and it's related to or connected to. And that would clearly encompass the general partner of MAA. Also, and this is in the definition of the term claim, is where they have the definition of landlord. The landlord is on that second page, the last sentence, 31. But in the broader definition of what is a claim, it includes anyone that has any relationship resulting from this lease. So to the extent that they're arguing that MAAC, as the general partner of MAA, can be liable, it has a connection to the lease. It would have the right to enforce the agreement. So that's it. I don't think I need to argue anything further. Those are the key issues.
All right. Thank you, Mr. Kelly.
I don't think there's any secret, Your Honor, that arbitration law is harsh. And obviously the result here would be harsh. She filed her lawsuit within 2 years of statute of limitations without having any idea that there was this 1-year limitations period and an arbitration provision. But the issue that we've raised is that the general partner is not a signatory to the contract. We didn't raise this in the first part of the case, and I wish we had, because if you look at the very last page of the contract, page 31 of 31, which is in Exhibit A1 to the previously filed motion, what's interesting
I'm having a problem pulling any of the exhibits up. I'm not saying it's y'all's fault, but I'm in box and I'm trying to open it and it just says, anyway, I'm struggling to get to page 30. So
If there's
And I
any-
also don't understand if it's page 30 of the whole packet out of 52.
Yes, Your Honor.
Okay.
I'm referring to that. I'll let you get there first, Judge.
Okay. Here we go. Paragraph 24, arbitration. All
That
right.
that is the provision that Mr. McKay is looking at. What I'd like the court to focus on is literally the signature page, page
Okay.
31, page 31 of 31
Of the contract itself.
of the contract itself. And
Okay.
when we say that MAAC is not a signatory, nobody on the defense is a signatory. The only signature that you see is an electronic signature, which we all know how that was done by my client, and it was not countersigned by any signatory. Wish I'd have raised it in the first hearing. I didn't. But we would argue, Judge, that they can't enforce a contract they didn't sign.
Okay.
The contract requires two parties, and here we only have one. So that's my response.
All right. Thank you. Did you want to have a brief reply, Mr. McKay?
Very briefly, yes, Your Honor. That's the distinction between an executory and a non-executory contract. An executory contract does not require a countersignature, and the way you can tell the case law on that is you tell, is there a signature block? Did the parties intend for there to be a signature? There is no dispute that Miss Riley was on the premises pursuant to a lease that she entered into. She was on the premises as part of the lease. Therefore, she executed, or the parties executed by performance. You don't need a signature if you have execution by performance, which is the executory. I think I said that wrong, but this was executed by performance. There is no signature line for MAA that is not signed.
Well, with respect to why she was on the property generally, that may be true. But Judge, there are other people that are on this property at that dog park, which actually goes to the language. And again, I'm going back to the first motion where they say that this lawsuit could not be maintained without reference to the contract. And that is simply not true. In fact, that was one of our arguments before, is that a stranger to this contract could have walked onto this property, slipped down in the exact same way, and not be bound by this arbitration provision and have a cause of action. So the contract really has nothing to do with the cause of action. It only has to do with binding a signatory to the contract by a non-signatory. So I stand on my argument.
Okay. Well, I'll take it under advisement and take a look. Are there any deadlines coming up?
No, Your Honor.
I don't think so.
Okay. All right. Thank you very much.
Thank you,
That concludes the hearing. You're both excused.
Thank you, Your Honor.
You're on mute.
Good
I'm
afternoon,
going
Your
to
Honor.
bring in the
Catherine
last
Hanna
case.
for Safeco.
Yeah. Are you replacing Ms. Hardesty?
Yes.
Okay. All right. Well, we're here on a motion to continue, I think.
Yes, Your Honor. May I proceed?
You may.
Yes, this is a first motion for continuance in an uninsured, underinsured motorist case. The parties have been diligently preparing for trial, but in early February, the plaintiff filed a number of additional billing affidavits. We need additional time to have our experts review and address those affidavits. The case has not been mediated. It is set for mediation prior to the trial date. I think 5 days prior to the trial date is the mediation setting. So we request a continuance so that we can complete discovery, particularly of the experts, and prepare for trial and hopefully settle.
All right, Mr. Dunn.
Thank you, Your Honor. This is personal lines UIM policy. No surgery, 110,000 in medical. Case has been pending almost 2, which is about right for an urban county. Should be tried within 18, 24 months. We have no requested depositions of their expert. They have a billing expert and they have a doctor. I don't care to take either of those depositions. We have one expert who is a doctor who will testify as to necessity and also as to the cost of the medical care. And we can schedule his deposition between now and April without any problem. He may already be scheduled. I apologize, I don't know. The mediation is scheduled for about a week before the trial date, which I think is an effective mediation date. I get a lot more cases settled when you're mediate right before you go to trial. You have to get your case ready, but a case like this, I can get ready on in about a trial at the most. The adverse has settled. There's a rear ender. Personal injury is not, the liability isn't really disputed. It's just how much over and above the amount of money that the adverse has paid is what Safeco owes. And that's not their problem. That's the Supreme Court in their rulings regarding UIM cases and how they changed contract law regarding their responsibility. So that's kind of where we're at. We would ask that the motion be denied, Your Honor.
All right. Anything else, Ms. Hannah?
I would just like to respond briefly that it's incorrect to say the case has been pending against my client for 2 years. Mr. Dunn may have had the case pending against the tortfeasor, who's he's calling the adverse. Safeco was not joined at that time. Safeco was joined later. I'm not complaining about UIM law or procedure. I'm simply saying for a first motion for continuance in order to complete discovery, I think that that would be the appropriate way to be able to have a case properly prepared and presented to the court.
Well, I would love to give everyone all the time they need to get ready for cases, but apparently I am supposed to make sure cases close. That's most important. The motion is denied. Hopefully you have enough time. I'm going to go off YouTube because I want to say